we are following some new developments out of a Milwaukee courtroom where the defendant is Darrell Brooks. You'll remember him from the Waukesha parade crash trial where he was convicted of killing multiple people with his vehicle. He also was accused of trying to run over the mother of his children just weeks before that parade attack in November of 2021. He was charged with intimidation of a victim, intimidation of a witness. She ultimately would testify against him at that parade crash trial, but this new trial is about her case. Let's go in live and listen to what the judge is saying to Darrell Brooks.
Mr. Brooks, it is my understanding that you are planning to enter a guilty plea today to two charges. See, I told you I would do it.
I know you did.
It is habit. I apologize. A no contest plea to two of these charges that are pending against you. Is that correct?
Yes, Your Honor.
All right. Have you had any drugs or alcohol in the past 24 hours?
No, Your Honor.
Are you on any medications?
No, Your Honor.
Are there any medications you're supposed to be taking that you have not taken?
No, Your Honor.
All right. You've been charged with a number of counts in each of these cases. It's my understanding that you're going to enter a guilty plea to the two, did it again, no contest plea to the two, and then the other charges will be dismissed and read in. What that means is for the dismissed and read in counts, you will not face any penalty for those, nor will you have a conviction for them. However, when we get to sentencing, the state will make their argument as to the facts of the case, and they can argue the facts that relate to those dismissed and read-in charges, and I can take those into consideration when I sentence you on the two that you entered the no contest plea to and that you were ultimately found guilty of. Do you understand that?
Yes, Your Honor.
All right. So for the two that you are going to enter the no contest plea on, the first is a second-degree recklessly endangering safety with a domestic abuse assessment. That means that it is a Class G felony, and for that you face the potential penalty of a fine of up to $25,000 and imprisonment of not more than 10 years or both. That 10 years is broken down into two parts, 5 years initial confinement and 5 years extended supervision as a maximum. Do you understand that's what you're facing?
Yes, Your Honor.
In addition to that, because of the nature of the crime, that this is someone that you have been involved in a domestic relationship with, or either resided with, or have a child with, you would face the domestic abuse assessment for that, which is just an additional $100 penalty that would apply against you, as well as a federal ban on ever possessing a firearm. Do you understand that?
Yes, Your Honor.
All right. And then on the count one, felony intimidation of a victim, that you're going to enter the no contest plea on in case 21 CF 5020. That is also a Class G felony, potential penalty of a fine of up to $25,000 and imprisonment of not more than 10 years, or both, broken into that 5 years initial confinement and 5 years extended supervision piece. Do you understand that?
Yes, Your Honor.
Do you also understand that if you were to be sentenced to prison, you would have to serve in prison each day imposed as initial confinement, because initial confinement time is not reduced by good time or by parole?
All right, there you have it. Darrell Brooks pleading no contest to two charges. Let's bring back in Joe Tamburino. Joe, you said it just 10, 20 minutes ago that there really wasn't a point to going to trial on this one. Your thoughts on the judge's decision and these parties' decision together?
It all makes sense. I mean, there are three types of pleas: not guilty, guilty, and no contest. And no contest means that, yes, you are going to be considered guilty, but you're just not saying it on the record because the evidence is more than enough to convict you at trial. And this makes total sense because he's already serving all of these life sentences. Why go through another trial?
Well, why bring the jury in? They were going to try and impanel a jury for this case. Class G felony, we raised our eyebrows on this one, a second-degree reckless endangerment and intimidating of a witness. Your thoughts on these charges that were against him in the case?
They're on the lower end of the felony spectrum. In Wisconsin, you go from a level A down to a level I. A is life in prison, B is up to 60 years, C is up to 40 years. This is the lower level of the spectrum of felonies, but we do know that that's because the victim wasn't injured, seriously. So she's not debilitated. So again, it makes sense.